So, what do these cases look like? So far, the plaintiffs tend to be fiction and nonfiction authors, comedians, politicians, artists, cartoonists, and photographers, as well as publishers like the New York Times and Thomson Reuters, and music groups like the Universal Music Group. The suits are generally directed at AI companies, and plaintiffs are typically pleading both direct copyright infringement and secondary liability. And as you can see, nearly every major generative AI company has been pulled into this legal fight, including OpenAI, Meta, Microsoft, Google, Anthropic, and NVIDIA. So there are a few theories that plaintiffs typically advance for direct copyright infringement. First is a training-based theory, so alleging that the AI companies violated their copyrights by training their models on copies of plaintiffs' works, whether that be photos or videos or text. And then other theories have focused on outputs. So they're saying, hey, you generated something that looks exactly like my work, which follows a reproduction theory of copyright. And there has also been a derivative work theory that has been somewhat rejected by courts. For example, Judge Chabria said that, rejected that theory and saying that, passing your work through a model and then generating using many other images and the statistical relationships learned through those images doesn't amount to creating a derivative work in the output. So that's a third theory that has fallen a bit out of favor. There have been two major opinions in the copyright context, and I'm not going to go too deep into these because there is a session focused on trends in copyright. But these two opinions are extremely important and will shape and have shaped the litigation in the copyright context. And before I dive into these two cases, I'll talk a little bit about the concept of fair use, which is a defense to copyright infringement. And basically, there are a variety of factors, four factors that courts assess to determine whether use of a copyrighted work is fair. But I'll focus on the first and fourth factors, which courts have found to be most important. The first factor relates to transformativeness. So, is this use of this work transformative such that the purpose of the end product was not the same as the purpose of the initial work that was alleged to be copyrighted? And the fourth factor is market harm. So, did the output of your AI model cause artists or authors to actually lose market share, or did it create a new market that didn't actually relate to the initial art or text or book markets at issue? So in Bartz versus Anthropic, a case in the Northern District of California, the court held that training on copyrighted books can be fair use. However, using books that were pirated did not amount to fair use. And based on that, the court certified a class that consisted of the authors that were in these copyrighted pirated data sets. And Anthropic, seeing this decision, later settled for about $1.5 billion. But this approach isn't necessarily the only approach, as we saw in Cadre versus Meta Platforms in Northern District of California as well. A district judge, Judge Chabria, held there that while training can be fair use, proof of market harm can actually sort of swing things the other way. He pointed out that in this case in particular, there wasn't sufficient evidence to see that the market for plaintiffs' works was actually harmed, but explicitly reserved and said that if there were more evidence of that presented, then the fair use decision might actually come out to be the other way. And so, this is the framework that we have for some of these ongoing cases against OpenAI, for example, which KVP represents for training based on text. And then there are additional cases pending for Stability AI, Runway, which KVP also represents, DeviantArt, and Midjourney relating to image training and videos. And then there are a few pending cases relating to music training as well, based on apps that generate new music.